Today is day 2 of the mock trial unit. Okay, and today we're going to look at parliamentary procedures, introduce some of the objections that you use, and just keep in mind the objection quiz is the day after tomorrow. And then with the objection quiz, you're going to be given a scenario, 4 options to choose from, and then you just pick which objection it is. So you can start looking at the objections, okay? Now reviewing them for the quiz in 2 days. So there are 2 sides to every court case. You have the prosecution or plaintiff if this was a civil case. And then you have the defense or respondent if this was a civil case. So prosecution, defense for criminal case, plaintiff and respondent for civil cases. The prosecution is responsible for proving without beyond a reasonable doubt that the accused is created for the crime. And then civil cases, it's not necessarily by a reasonable doubt. For the defense, you only have to poke holes in it and apply a different theory for the crime. Reasonable, the prosecution must establish, has the burden and must establish beyond a reasonable doubt. Therefore, the defense only has to create a reasonable doubt, provide an alternative theory, provide an alternative reason for what has happened. Again, as I talked about yesterday, the trial has 3 parts. We have the openings and closing statements. We have then the examination in the middle. We have direct and cross. So in the opening statement, the prosecution will lay their case out. They will preview their case, followed by the defense. And if the judge allows it, you may have a rebuttal. Typically, you do not have a rebuttal opening statement. The trials, you have the direct examination where you are giving, examining your witnesses, and then the opposing counsel will examine your witnesses and vice versa. That is known as the cross. Think about going across the aisle. You're doing a question of people that are not your witnesses. Then finally, we wrap it up. Think of it as a conclusion paragraph. Prosecution goes first again, followed by the defense. If there is time remaining and the prosecution did yield and want to reserve the right to rebuttal, they can. So you have to ask for it and the judge has to approve it. You definitely, if you have the prosecution side, you definitely want a rebuttal. You don't want to leave the defense's case last in the jury's mind. So as I talked about in the previous lesson, the opening statement is more of a, think of it as a movie preview. Always address the court. If it pleases the court, is a good opening line. It should be kind of like natural. It should be ingrained. It's kind of like how we do our pro and con debates. State where you're from, your name. Okay, my name is Mr. Miller, Buford delegation, and I am in for or against such and such. So it should just be a memory thing by now. Always phrase the next line. We are going to show you that, we will provide proof that you're going to see over the course of this trial that, and then go into your opening statements. Should last no more than 3 minutes long. And really what you are trying to do is you're just trying to provide an overview of what's going to come, what each of the witnesses are going to kind of testify about. Never really use the phrase we already showed you, because obviously we're still in the opening statements. Don't say that, the accused did this, and that's the ultimate issue. We don't know whether or not they've done it. Okay. And while you don't do this, you're already giving them the movie. They haven't even watched the movie. Keep your opening statements to 3 minutes long. Following both sides' opening statements, we go into the examination. Prosecution will go first. They will question their witnesses first, which is the direct. Okay. And you need to let your witnesses give the talking, do the talking. They are the star of the show. Okay. You know, some typical sentence starters. Tell us about the night of. Were you present at the night of? Do you recall the night of? Okay. We need to lay that foundation. Once they prove that they can recall it or that they were there, then further have them explain further what's going on. Okay. Never lead a witness under direct examination. Again, leading questions are things that ask closed-in topics. Isn't it true that you loaded the gun that night before you killed your husband? Again, that's a yes or no answer. And my guess is in this example, the ultimate issue, the charge was murder. So you can never ask a question about what the verdict is going to be or what the actual court case is. That is called ultimate issue. The witness has to tell the story. The attorney may not lead the witness in any shape, form, whatsoever way possible. Okay. It needs to be a story coming from the witness, but not so much a narrative where you still need to have some questions. Okay. Don't make it all story. Have some questions in there. Rule of thumb, if the answer is a yes or no, then you cannot ask it during direct. You can ask it only during cross-examination. Now, again, cross-examination is the questioning of the other side's witness. Think of it as a hostile witness because you don't know how they're going to respond to your answers. Okay. These are questions to opposite teams' witnesses. After the direct examination, the witness will stay on the witness stand, and the other team, the other lawyers are going to ask them questions. Now, when you are the lawyer doing the cross, you want to control the witness. Unlike the direct, where the witness told the story and you let them be the star of the show, cross-examinations, you control it. You are the star of the show. So control the witness. Always ask them to answer all questions without yes or no, unless otherwise asked. You're asking the judge to tell the witness that. Okay. You can do that in pretrial motions. Examples of what is okay, almost anything, because you're controlling the witness. As long as you are controlling and leading the witness, questions are okay. Do not ask open-ended questions. If you have time and you are doing direct and you have time remaining with the witness and you ask permission to redirect, go ahead and redirect, because you don't want the last thing in the jury's mind, the judge's mind, any of those cross questions. Turn those negatives back into positives, just like we did with pro and con debates. Objections. This is where we're going to try to kind of change gears and get you guys into getting ready for the upcoming quiz. Sometimes an attorney is breaking the rules and the witness is breaking the rules, or there is just momentum swing to the other side. Go ahead and call an objection. Only the attorney that is responsible for asking the questions may object. Nobody else on the attorney team can object, but the attorneys that are not questioning the witness should be paying attention and try to assist the questioning lawyer as much as possible. After the objection and arguments from both counsels are heard, the judge is either going to sustain or override it. A sustain means that the objection was valid and correct. An override is that the judge doesn't think the objection was correct And some of the objections that we're going to talk about are leading, argumentative, badgering, hearsay, ultimate issue, asked and answered, and outside the scope. Okay, we're going to go through all these in further detail. Leading can only be used when direct examinations are occurring because you cannot ask yes or no questions. Stating the question that has the answer built into it so the witness can just confirm it or deny it is incorrect. You can't ask that. Did you go to the cafeteria today? Yes, that is a leading question. Isn't it true that you had a chicken salad sandwich for lunch today? That is a leading question. For example, what did you have for lunch? Did you have a chicken Caesar salad for lunch? Didn't you? First one is not leading. It is an open-ended question. The person could answer, yes, I had lunch. No, I didn't have lunch. Okay. Yes, yes or no, but it's not asking for just a yes or no. The second one, yes, leading. It's getting to the actual type of meal. Isn't it true that you have no siblings? How many siblings do you have? First one is okay and cross. It's still leading because the question is embedded in it. The second one is okay and cross and an okay and direct. We don't know how many. Argumentative and badgering are kind of the same thing. You are starting to argue with the lawyers. You're arguing with the witness. The witness is arguing with the lawyer. Did you do this? Respondent says no. Are you sure you didn't do this? Yes. Are you positive you didn't do this? Yes. You did this. Why aren't you admitting to it? You're starting to be confrontational. Badgering is the same thing as arguing. Okay. Speculation and foundation. Speculation is asking the witness to make a guess. No one may make a speculation unless it is an expert witness inside the realm of their expertise. Let's say you went home instead. What do you think might have happened if, okay? Those causing the witness to make a guess, those are some wrong, that's wrong, and you must kind of start listening for those phrases. Foundation only happens on the directs. This is a big one, okay? You must lay foundation. You got to put the person there holding the candlestick over the murdered body, okay? If the attorney has not established a foundation for a question, they can't ask it. So, were you at school today? Yes. Did you have lunch today? Is lunch in the cafeteria? Yes. Okay. I have now put the person in the cafeteria for lunch. I just can't start going to cafeteria. First question of the direct examination. So when you were at the party, who did you see drinking alcohol? I never established that the person was at the party. Okay. Plus, this is a compound question. There's two questions in it. Okay. The best way to lay foundation and avoid this mistake or this objection is go chronological. Hearsay, firsthand knowledge. Hearsay is you don't have firsthand knowledge. Firsthand knowledge is firsthand knowledge. You aren't American. You didn't do it. You didn't say it. Okay. Asking questions that the witness doesn't know from firsthand experience is not allowed. You can't ask a witness what Susie said to him that he heard from Billy Bob. Okay. Billy Bob has to tell you directly. Was Josh driving that night? Well, I heard. Okay. Okay. Right there, you could go ahead and object. The witness didn't see Joshua driving, didn't know that Joshua was driving. Okay. How credible is the source that he got it from? Now, if you don't get in the objection and the question is answered, then the follow-up question might be, how did you know? I heard from Susie. Okay. I heard from Susie. There's another chance to get in a hearsay because was Susie there? And more than likely, no. Ultimate issue. This is what the crime is. So never ask, did you commit the crime? That is why we're having the trial. That's the ultimate issue. This is why everybody's here. That's why we are having the trial. You can't ask, did they commit the crime? Asked and answered. This is when the attorney has asked a question and the witness is given an answer, and then the attorney asks for the answer again in the same question, even if it is paraphrased. Lawyer asks, did you kill him? Yes. Right off the bat, that is ultimate issue, but let's just go with this. So like you really killed him. The witness already answered yes. Objection, asked and answered. Like shot him in the face and he died, actually. That is, again, asking the question. The way to get around this and tread very lightly on this is ask the question, and then at the end of your examination. So let me clarify. You said X, Y, and Z, correct? Okay. Even so, you can ask clarifying questions, and if your judge is not acute to it, he may or she may allow it. So the only people that can ask or be asked questions and they guess on it is establishing an expert witness. So in order to establish a witness as an expert, you got to prove that they are academically good at their job. They've had some time in their position. So you might ask, like, what are their credentials? Like, what do they do? What are their jobs? How long have they done it? What books or research have they done? What awards have they gotten? What sort of degrees might they have? And then once you ask those questions and you feel like the witness has established that they are an expert, then you can go ahead and say, Your Honor, I would like to establish this witness as an expert in his or her fields, which are A, B, C, D. And then you would list what you want to do. Then the judge will say to the opposing counsel, are there any objections? Okay. Now, you can say, no, I object. And then you need to have an argument, because sometimes you might feel that the witness didn't prove beyond a doubt that they have the academic credentials. They haven't had enough time in the jobs. They haven't proved that they are an expert. Or you may just try to say, okay, we acknowledge that they are an expert in this. We disagree with this. And then the judge will make a ruling. And in order to put something into short-term, into long-term memory, you have to say it 3 times. And if you think about our theme of our trial, we're going to introduce it the first time in opening statement, the second time during the examination, and we're going to intertwine that theme during the examination through all 3 witnesses, and then bring it back up in the closing argument. So closing arguments typically are written as the trial is progressing. The opening statement you can have written ahead of time. Closing statements you can have the most of it or kind of some of it written during, because you know what you're going to bring out. You just got to fill in the blanks of how that trial went throughout. Okay. The attorney giving the closing will know what his or side will be trying to prove and attempt to prove it, so that they can write some sort of it before the trial. And that's what I'm saying. You can have the shell written. Now, the person that gives the opening cannot give the closing. You have to switch. So if you are better with impromptu speaking, do the closing. And if your partner is better at informative speech, have them do the opening statements. So after the closing argument is done, the jury is quote unquote sent out and to deliver the verdict, and we come back. This is really not necessary at YIG. It's just point scores. One thing I did forget to mention about the closing argument is If time remains and you ask for it, make sure you ask for a rebuttal statement. You don't want to leave the jury, you don't want to leave the judge's last impression on the defense side. You want to, if you're the prosecution, you want to end on the prosecution side. All right, tomorrow we're going to talk about objections, and then 2 days from now we will have the objection quiz.